Hi, I'm Debojit Das, and this is LiveLaw Daily. Today, August 18th, at least according to the widely accepted account, Subhash Chandra Bose is believed to have died after a plane crash in Taiwan on August 18th. Though the circumstances surrounding his disappearance have remained a subject of debate for decades, but keeping the importance of today in mind, let's get to today's top stories from India's courts. For our first story today, the Supreme Court is considering a challenge to hanging as the method of executing the death penalty in India. The court has now reserved its order in the matter. A bench of Justice Vikram Nath and Justice Sandeep Mehta heard a public interest litigation filed by senior advocate Rishi Malhotra, challenging Section 354, subsection 5 of the CRPC, which provides that a death sentence is carried out by hanging the prisoner by the neck until death. The petitioner argued that hanging can involve prolonged pain and suffering, and has suggested alternatives including lethal injection, shooting, electrocution, and gas. During the hearing, the court considered arguments on whether hanging causes unnecessary pain and whether another method of execution could better protect the dignity of a prisoner. This issue has been before the Supreme Court since 2023, when it considered setting up an expert committee to examine the pain and medical impact associated with hanging and possible alternatives. For now, the court has reserved its orders on the challenge, so the question on whether hanging should continue as the method of execution remains before the Supreme Court. For today's second story, the Supreme Court has been examining how far police can go in using social media to display accused persons. The court was hearing a plea seeking guidelines on police uploading photographs of accused persons on their official social media accounts, particularly where those images show them being handcuffed, tied with ropes, paraded or otherwise portrayed in a degrading manner. A bench of Chief Justice of India Suryakant, Justice Joy Malia Bagchi, and Justice V. Mohana heard the matter, with senior advocate Gopal Shankar Narayanan appearing for the petitioner. The plea raised concerns that such images can compromise the dignity of the accused persons and contribute to what was described as a social media trial, creating a public bias against them even before their guilt is established. The petitioner had also raised concerns over police accounts in states including Gujarat, Haryana, Maharashtra, Assam, and Chhattisgarh. During the hearing, the court pointed out that in another POCL matter, it had already directed states to frame guidelines governing police media briefings and observed that those guidelines could also cover social media postings. The bench suggested that the petitioner await those guidelines. Justice Joy Malia Bagchi also indicated that the issue could require broader consideration beyond the immediate petition. Following the court's suggestion, senior advocate Gopal Shankar Narayanan withdrew the petition, with liberty to approach the court again with a broader plea. For our third story today, the Supreme Court is now looking at what should happen to the criminal cases arising from last month's student protests. And the court is drawing a line between students who came out to protest and those accused of serious crimes. A bench of Chief Justice of India Suryakant, Justice Joy Malia Bagchi, and Justice V. Mohana indicated that FIRs against student protesters could be quashed, while those with a history of grave offences would be treated differently. Solicitor General Tushar Mehta told the court that apart from 2,873 people facing serious cases involving offences such as murder, rape, and abduction, FIRs against the other protesters could be quashed. He said antisocial elements who had entered the protests would need to be investigated separately. But Advocate Rizwan Ahmed, opposing withdrawal of those cases, argued that the students should first file affidavits expressing remorse. He also contended that the July 20th Parliament March was unlawful and that participation in a protest did not automatically remove criminal liability. The Chief Justice of India stressed that the court must consider why the students had gathered while also keeping in mind their Article 19 right to peacefully raise their voices. The court has also allowed investigations to continue, but directed that no coercive action can be taken against students with no criminal antecedents. It also ordered the release, where necessary on simple bond, of children below 18 with no criminal history who were detained or arrested in connection with these protests. The court said that the issue concerns the life and future of thousands of students. For today's fourth story, Captain Ashish Kumar was presumed dead after a missile or drone attack on a merchant vessel in the Strait of Hormuz. But later, a DNA test came back negative, and now his wife is telling the Supreme Court that he may actually be alive and being held captive. Kumar was on board the empty skylight when it was allegedly attacked near Khasa port in Oman on March 1st of this year. 18 of the 20 crew members were rescued, but Kumar and another Indian national were reported missing. Burned skeletal remains were later recovered from his cabin, leading authorities to presume that he had died. But then came the DNA test. The remains were tested against a sample from Kumar's brother, and the match came back negative. The Indian embassy in Muscat reportedly confirmed this to the family on May 15th, while an Omani forensic report reportedly found no human DNA in the bone fragments examined. His wife has now approached the Supreme Court claiming that Kumar is alive and being held in illegal captivity by foreign actors. The bench of Chief Justice of India Suryakant, Justice Joy Malia Bagchi and Justice V. Mohana had sought a status report from the Union. The Chief Justice of India told Solicitor General Tushar Mehta to take cognizance and find out from the authorities. The court also noted allegations of ransom calls to the wife and misuse of Kumar's mobile phone, with the Chief Justice of India observing that these circumstances could indicate that he is alive. The Union has now been asked to look into the matter and report back to the court. For our next story today, the Calcutta High Court is examining West Bengal's decision to re-verify caste certificates following the ongoing Special Intensive Revision or SIR of electoral rolls. The state's Advocate General told a division bench of Acting Chief Justice Tapabrata Chakraborty and Justice Atarup Banerjee that caste certificates issued on the basis of voter identity cards from 2011 onwards would require re-verification. Certificates issued on documents such as PAN cards, however, would not be subjected to this exercise. The issue came up in a plea by the CPIM, challenging that it calls a blanket re-verification exercise. Importantly, the state clarified that deletion of a person's name from the electoral roll during SIR would not by itself cancel their caste certificate. When the bench specifically asked whether a caste certificate could ultimately be revoked after a person's name was deleted from the electoral roll and the certificate was re-verified, the Advocate General answered in the affirmative. The court then pointed out that such a consequence was not in the statute. The Advocate General maintained that the exercise would be carried out according to law. The Petitioners' Counsel, Senior Advocate Bikash Ranjan Bhattacharya, clarified that the challenge was not to legitimate re-verification, but to the manner in which the state had ordered this exercise. The court is now examining whether the state's proposed process has sufficient statutory basis. For today's sixth story, the Bombay High Court has granted bail to Sachin Andure, one of the men convicted in the murder of rationalist Dr. Narendra Dabholkar, nearly 13 years after Dabholkar was shot dead in Pune. A division bench of Justice Sarang Kotwal and Justice Ranjit Sinha Bhosle also suspended Andure's life sentence while his appeal against the conviction is pending. Narendra Dabholkar, who campaigned against superstition through the Maharashtra Andhshraddha Nirmoolan Samiti, was shot by two men on a motorcycle while he was out for his morning walk on August 20th of 2013. The CBI took over the investigation in 2014 and identified Andure and Sharad Kalaskar as the alleged perpetrators. Kalaskar was granted bail by another Bombay High Court bench in April of this year. Sachin Andure's lawyers focused on the identification evidence, pointing out that the CBI had not conducted a test identification parade, even though some witnesses subsequently identified him in court. They also highlighted differences in the witnesses' accounts about whether Andure was actually seen at the spot, along with his prolonged period in custody. The Dabholkar family opposed the bail, arguing that his release could send the wrong message. They referred to the killings of Govind Pansare, Gauri Lankesh and M.M. Kalburgi, arguing that these cases reflected a wider conspiracy targeting people who challenged superstition and promoted rationalism. The detailed order is yet to be made available, so further details of the court's reasoning are awaited. And for our next story today, the Delhi High Court has put a hold on Jawaharlal Nehru University's postgraduate admissions using deprivation points while the challenge to the system continues. Under JNU's e-prospectus, candidates can receive up to 12 deprivation points, with each point equivalent to 3 marks based on the geographical location of their previous schooling. The challenge argues that this effectively alters a candidate's CUET score and undermines the purpose of a common entrance examination. JNU, however, has maintained that the deprivation point system has been in place for several years, with amendments over time and approval from its academic council. It has also pointed out that admissions had already taken place and classes for some postgraduate courses had already begun on July 30th. The court is examining whether adding deprivation points to a candidate's score after the entrance examination has been conducted has a sufficient legal basis. For now, the admissions process has been put on hold, with the matter to be considered further by the court. For today's 8th story, the Supreme Court is hearing the long-running dispute over the Shiv Sena split, with senior advocate Kapil Sibal challenging the Maharashtra Speaker's decision not to disqualify the Eknath Shinde faction MLAs. A bench of Chief Justice of India Suryakant, Justice Joy Malia Bagchi and Justice V. Mohana is hearing the 2024 petition filed by Sunil Prabhu on behalf of the Uddhav Thackeray-led faction. Another petition concerning the Election Commission's recognition of the Shinde faction as the official Shiv Sena is also before the court. Sibal is currently making submissions on the disqualification issue under the 10th schedule. His central argument today is that the concept of a split in the legislative party has no place under the 10th schedule. According to Sibal, when MLAs are accused of voluntarily giving up membership of the political party, they cannot defend themselves by claiming that the legislative party itself represents the political party. He has also challenged the Speaker's approach to determining the party's leadership and constitution. Sibal argued that the 2018 Shiv Sena constitution and leadership structure had to be considered, particularly because the Supreme Court had already dealt with the issue in Subhash Desai. He questioned how the Speaker could instead rely on the 1999 constitution, which was on the ECI record, and use it to conclude that Uddhav Thackeray's position as Paksh Pramukh did not represent the will of the political party. Kapil Sibal also stressed that the legislative party cannot simply be treated as the political party. The 10th schedule itself distinguishes between the two, he argued. Another important submission is about the whip. Kapil Sibal says that the whip was with the Uddhav's faction and that MLAs who voted against it should have faced the consequences under the 10th schedule. He is also relying heavily on Subhash Desai, where the Supreme Court said that when rival factions emerge, the Speaker must examine the party constitution submitted to the ECI before the factions emerged, rather than allowing competing versions to determine the outcome. The court is going to continue this hearing next time. For today's final story, one that I think should get slightly more attention than it is getting, the Odisha High Court Bar Association is raising concerns over what it calls a standstill situation caused by the shrinking strength of judges at the High Court. The association, led by the President's senior advocate Lalatendu Samantrai, held a press conference on Monday, pointing out that the court currently has just 17 judges, including the Chief Justice, against a sanctioned strength of 33. And the situation gets a lot worse. Two senior judges, Justice Manas Ranjan Pathak and Justice Krishna Ram Mohapatra, have already recommended for transfer. Two senior judges, Justice Manas Ranjan Pathak and Justice Krishna Ram Mohapatra, have already been recommended for transfer. If those transfers go through, the strength will fall to 15 judges. Then, with the Chief Justice and another justice due to retire in November, it could drop further to just 13 judges. That would leave 20 vacancies out of 33, even as more than 1.72 lakh cases. That would leave 20 vacancies out of 33, even as more than 1.72 lakh cases are pending before the High Court. The Bar Association has therefore urged the Supreme Court Collegium to act quickly and fill the vacancies. The sanctioned strength was increased to 33 in 2022, but the court was never operated at full strength since then. The last appointments were made in September of 2023. The association has also pointed out that no judge from the Odisha High Court has been elevated to the Supreme Court in the last 15 years, with Justice Deepak Mishra being the last back in 2011. That's all for today's LiveLaw Daily episode. You can find the link to every single story on the description box below. Keep following LiveLaw for the latest developments from the courts, and we'll see you tomorrow.